Welcome to Baker's channel where stories unfold, covering trials, dramas untold. Grab your seat, settle in, start the show. Courtroom clashes, the fun we bestow. Baker's channel, action's hot, trials and fun, all we got. Discuss, debate, break it down. Baker's channel, chat's the best in town. Lawyers spar, tensions high, sparks fly. We laugh, we learn, dive into the why. Join the chat, have your say, it's your place too. Every twist, we're here for you. Baker's channel, action's hot, trials and fun, all we got. Discuss, debate, break it down. Baker's channel, chat's the best in town. Stay and please like join the crowd. Baker's channel, we're live and loud.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any you are. Welcome, Mark.
How are you?
I am doing wonderful. Karen Reed, the case we can keep on grifting. Well, I need to up my grift. It's
I don't know. This is a transcontinental grift. This is
yeah, but you did make the list. You're home free. Yellow cottage cheese hates you already. Me, it probably doesn't even know me.
Well, you know, I've been lobbying to have you put on the grifter list, so this will help.
Me and Massa, I think we have done enough work to be on the list, but it's elitist. I feel it's because I think it's racist because I'm Danish.
Could be.
I think it's somewhere like that. Yeah, we have Europeans here, and we have South Africans. It's
worldwide,
it's international.
Great.
But the reason I called on you today was because we had a new filing. The former double hearsay, Juror B, contacted Janetti directly on the phone and confirmed unanimous not guilty verdicts on 1 and 3, and told me the only charges on which the jury was deadlocked was indictment 2. Told me she was familiar with the affidavit that had previously filed in support of the motion. Jury B confirmed for me that the screenshot of text message exchange that I referenced in paragraph 4 of that affidavit was accurate. Specifically, Jury B confirmed that she had texted it was not guilty on second degree and split in half for the second charge. When the judge sent us back for that Hernandez, was it Hernandez? Isn't it some other name?
Tui Rodriguez, Hernandez, Rodriguez, I guess, you know.
Yeah, the go back and talk about it again motion. Thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. That sentence, I don't get that sentence.
He's writing it the way it was told, hence the spelling incorrect. He's
this one.
Clear that I'm quoting what I was literally told, even if it isn't the best prose in the world.
Yeah. They gave us free counseling forms when we left. Juror B clarified, however, that she meant to write no one thought she hit him on purpose or even knew that she had hit him. Jury B believes every member of the jury, if asked, will confirm that the jury reached not guilty verdicts on indictment 1 and 3. Jury B believes that even jurors who were leaning towards a conviction on some parts of indictment 2 will confirm that the other 2 indictments were acquittals. She believes that other jurors have been reluctant to come forward because there's so much public and media attention focused on this case. So, another confirmation that the jury room was in agreement. But Bev will rule Friday that doesn't mean anything, and state will just move on.
Well,
All.
we'll see. I mean, this is reducing one level of hearsay that's true. It's still hearsay. It's just not double hearsay on that one. But you also have what the DA kind of sheepishly admitted last week, saying that we did in fact hear from some jurors, one of whom told us, in essence, that it's true that we acquitted on those 2 counts, although they're very ethical and pious prosecutors, so they didn't want to talk about anything further, so they let it go. But it's putting a lot of pressure. It's putting a lot of pressure on the judge to just simply develop the evidence, and it's also putting a lot of pressure on the DA, irrespective of what the judge does, because at this point, it's becoming clear whether they checked the box, why they didn't check the box, whatever they didn't literally do, that they meant to. And if we're not going to take evidence on why that is, and you don't want to hear the legal answer, there's a practical answer here, which is everybody seems to know at this point that they were acquittals on those 2 counts. And the people who also know that are prospective jurors at a retrial. And it's putting the DA in a terrible position where how can you possibly retry her for murder when everyone knows, again, put the law aside, just what's coming out and what appears to be a very consistent story, whether it's coming from jurors, intermediaries, being reported by the DA, being reported by 2 defense attorneys. There were acquittals here for some reason. And the idea that picking a jury in trial 2 for murder when they're all looking at each other saying, what the hell's going on here? I thought she got acquitted on that. This isn't, this is very un-American, very unconstitutional. The damage that the DA would be doing to itself is too extreme. So either way, the defense is winning this battle. Either the DA, the judge is going to have to hold a hearing, or at some point the DA is going to have to dump the murder charge. There's just no credible reason at this point for them to bring a murder charge. And of course, this kind of gratuitous comment that nobody thought she hit him on purpose, if she hit him at all. I mean, that's just a kneecap on, those 2 charges. I mean, that's basically saying this is a complete unawareness. So clearly there could be no intent to do harm if you didn't know you hit someone. And, it's kind of hard to leave the scene of an accident, which is part of count 3, if you don't know that you hit anyone. So that's kind of an important detail that really rubs the salt in the wound about, ironically, the deliberative process, which is, that is part of the deliberative process.
Yeah, because if we look at the original charges, it was murder. That's out the window because they unanimously don't believe that. And the other one, they don't leave the scene of personal injury or death, but they still believe manslaughter while OUI or some part of it. But
Well,
then why don't you have 3? If you believe she did 2, 3 should automatically follow.
Well, you can't be guilty of leaving the scene of an accident if you don't know that there was an accident. I mean, there is a built-in requirement there. So this actually makes perfect sense to me. I mean, if their thought process is that we didn't know, or we believe that there is no evidence that she knowingly hit him, even if we think she might have hit him, it's pretty tough to charge somebody with leaving the scene of an accident that you don't know happened. I mean, that would also be kind of a ridiculous prosecution. I mean, if you bump someone and literally have no idea, how can you be charged with leaving the scene of an accident that you didn't know happened? So this makes actually perfect sense to me, and is another detail that I think just is kneecapping the DA's overall theory that she had to have done it. And that leaves you with some working theory of at least 9 people at the time, some degree of she must have been absolutely wasted and just hit him. And then that's that. And it is what it is. If you try to unpack this, that seems to be where some of them are.
Yeah, but again, and I think, as you say, you can't keep murder on the plate, and without the murder charges,
Mhm.
you lose 7 weeks of testimony from the state. because then Aruba doesn't matter, snow doesn't matter, who
Text
was at
message.
the house doesn't matter, third
Text
party culprit, it's out the window, and then you can just focus on the facts.
The real question is the DA smart enough to know that in many ways the defense is doing them a favor? I mean, getting rid of the murder charge would be the best possible thing for the DA as well, if they really want to go forward and have a retrial, which I'm not convinced there will be for other reasons, even though they're entitled to on count 2. But in some ways, the defense, look, they have to protect their client. If you can get rid of the murder charge, you're going to do it. But will the DA recognize that in some ways the defense is doing them a huge favor? Probably not, but they should.
Yeah, but again, we know how bad Lally's factual evidence is. And if murder goes away, he has to look at his pile of evidence. He can get any of all that. She was mad at a 25-year-old because John was hugging her. She yelled at Jen when they drove by his past girlfriend. All of that will be out. You don't even need Jen McCabe to come to the courtroom now, other than to spread her smiling, charming being, because it'll just be, did she hit him?
Well, they would still want her to say that, go through her evolution. That's her story. I mean, her story of I hit him. But the reality is, at a retrial, they're going to destroy that story. I think they'll pay it more attention. I mean, when you basically think it through and realize what her version of events is, which is nothing at all about I hit him. I had a epiphany that she said I might have hit him after, we had a family meeting at 6:30 in the morning with, oh shit. She calls the cops back, claims she said, no, she told me I hit him. So that cop got it wrong. Proctor later got it wrong because she said I hit him, not I might have hit him. The federal grand jury process where she said 12 times apparently, or did not say this when asked to explain what was said. She has no explanation for that. She's a terrible witness. She's one of the worst witnesses you'll ever see. And with the benefit of time and preparation and a transcript, I think what the defense would do the second time around is really use the interviews that she gave the cops against her more and just attack her story more, attack her timeline of what she claims she saw more. And I also think pay more emphasis to the that really bizarre testimony about Julie Nagel and taking her texts and making sure, she basically cribbed her timeline. She wanted to know what it was before she gave it. I think they would pay more attention to this kind of weird testimony, how she sat, if I recall it correctly, she sat with Carrie was her name, and I think even John O'Keefe's mother, and made a timeline the day after the killing. I mean, that's what they're doing with John O'Keefe's mother. They're working a timeline out. I mean, that's weird, isn't it?
But it went over 8 weeks this time, and that big gig is asking, do we think they're going to call 1,000 witnesses again, and maybe like top 10? Well, the problem is they don't. What should they call them for?
Well,
you need someone to say, well, she acted that way when we found the body. But if manslaughter isn't on the table, you can throw a lot of the surrounding evidence out, and that's a lot of these, because the thing Lally was doing, he was just giving you so much. It's like I always show with my pile of paper. He gave you all of this evidence, and in here was something that might be useful. And when you go through all of it, you say, "Oh, that's so much evidence," but it's nothing.
This is a secondary problem for them, though, about going forward. I mean, in some ways, this is the kind of problem where it's akin to, shuffling deck chairs on the Titanic. They have larger problems about going forward. I mean, Proctor is obviously damaged beyond repair, and, you have to deal with that. But you don't know what's going to happen with Buchanan and Tully and how damaged they are going forward. And what happens if Buchanan is severely damaged? Well, who's going to talk about finding all this taillight piece that revealed itself? If Tully is damaged, who's going to talk about all the things that he did and the pieces of taillight that he was involved in and getting the CERT team together? And how, I mean, they have real issues that may not be resolved for some time. And if they lose all of these state troopers and supervisors, they may have a much larger problem than just paring down a case. They may have no case at all.
Yeah, we saw that in the Carolentala case too, where the lead detective didn't show up because they had so many mistakes. And there was a pro se litigant in Florida in the Treehouse case where the lead detective on the case had mistakes in 17 out of 19 cases. So now she was a 911 operator.
I mean,
calling them to the stand just shows, Jesus, this is bad.
Well, look at it this way. I mean, just put Proctor aside again. He's irreparably harmed and useless. But take Buchanan. He's got issues, right? He's under investigation. We don't know exactly what for. But look what he could get grilled about this taillight stuff. Is that part of his investigation? I don't know. He liked some of the text messages. That's a problem. But don't forget, if he thinks he's under investigation and he's got to tap dance through the minefield at a retrial, he's on the hook for this inverted video. That's all him. I mean, if you're his lawyer, you want to go over that? Do you want to explain that? I mean, that testimony that already happened, it happened, and you kind of, that's me. Oh, maybe that's not me. I didn't talk about the video the right way the first time, but okay, on cross-examination, I did. Do you really want to get into all that stuff? Do you really want to get grilled by Alan Jackson about that stuff again, knowing whatever else is going on? You've already seen what happened to Proctor. You've seen this case is going down the toilet. You've seen that you have no expert who's going to defend the taillight. I mean, here's the problem. Again, you have to look at this from like Buchanan and the state police perspective. The ARCA evidence, it's kind of a double whammy for them. Not only does it just provide reasonable doubt, but it provides another problem for like someone like Buchanan. If the taillight didn't get there from a car accident, then it got there unnaturally. And that means somebody threw it there. And, that kind of puts Proctor and Buchanan in the crosshairs for that. And with all these other problems going on and the inverted video and the text, who knows? I mean,
yeah, and that's going to be the interesting part again, because the thing about Proctor, they kept him on. They knew he had to be thrown out because of what he did, but they kept him on for this trial. This was the one and done. This was the World Series. This one should have been out of the park. She should have been found guilty. Then they could have swept all the corruption under the carpet. But those stupid jurors didn't find her guilty, and now Proctor's in trouble. Brian Albert's in trouble. We have to keep this going until January 27th. Brian Higgins probably will be in trouble because he used federal equipment.
He may not want to reappear. He's another one. You could make the same analysis like we did Buchanan. Look, they can force him to come back with a subpoena, but they can't force him to open his mouth and say what they want. He's not going to want to come back. And also, don't underestimate what the defense will do in 6 months' time in trying to learn things. I mean, the reality is, if they're looking into like the inverted video thing, who's to say that the DA's office doesn't get implicated in that? And how does that impact? I mean, they're the ones who put that evidence on with a straight face. Now, they may learn things that show that
they even defended it. Remember, Lally said, but it's the same. No, it's not.
Well, if by the same you mean it's inverted and there's people apparating in and out and the taillight is flipped so you're looking at the wrong taillight and it helps conceal Michael Proctor standing next to the taillight, and you testify that it's an accurate video of what's going on, I guess if that's what you mean by it being the same, it's the same. But I mean, that's kind of a silly argument, isn't it?
I think I don't remember if I discussed it with you before, but isn't there some legal or ethical obligation to not lie about evidence?
Of course.
Especially from the that's another thing, because a lot of people are asking about this. Will Bev throw out 1 and 3, and what happens if they throw it out? Well, we can't tell with Bev. Bev is a special little cookie, but the DA's office, as I understand it, is there to find justice. They're not there to get convictions.
That's right.
Or get revenge.
They are supposed to seek justice, whatever that means. Sometimes that means not filing charges for any number of reasons. Sometimes it means dismissing cases. Sometimes it means allowing a process to continue, such as whether the jury acquitted. I mean, I think most rational prosecutors would be concerned about what's going on with the jury in this case, even if they think they have an argument that maybe the defense waived their right. Most sane prosecutors would recognize making that formulaic argument and just sweeping aside the substantive argument, which is whether they actually acquitted her, is political suicide. I mean, there's going to be a lot of questions for the DA on, is that how you do justice? I mean, do you not care that you may be retrying someone who was acquitted? Again, whatever the defense objected to or not, most people would say you ought to flesh that out. Let's figure it out and see what this is. So,
Yeah, and
is that Norfolk County? So far, the evidence would suggest no, but we'll see.
And Nicholas says, Andrea Burkhardt says it's good for Karen, but legally it favors the Commonwealth. The jury expressed no confusion about their option and gave no indication that verdicts on any of the charges were possible.
I think that's reading into it too much. Those are fair questions, but that's why you need a hearing. Okay, these affidavits that are being submitted are based upon what the jurors are telling the lawyers who are writing it down literally, as we saw, word for word, even with bad prose and everything we talked about. But the idea is not to make a ruling based on hearsay and this and that. The idea is call the jurors in and let both sides ask the questions. And I think what Andrea is talking about, those are fair questions that people should know. I mean, the foreperson should be asked, why didn't you check the box? Why didn't you ask? That's all fair. And maybe the defense loses. I don't know. But these are issues that ought to be fleshed out at an evidentiary hearing, because there's a good faith basis to believe at this point, based on what you're being told, that they did think they acquitted her. Doesn't mean they're right legally, but it ought to be fleshed out.
No, and again, the difference between your system and our system is I've been doing this for 13 years. I kind of know what's going on. Oh, thank you, Brandi, for the rate. I sent Brandi a link if she want to jump on, because she has been covering that horrible case with the dad with the 3 little kids. That was a nasty case. But I kind of know what the rules are. But we watched the trial last week where the jurors asked to get access to some testimony, which I think could have swayed them in the way they saw the case. But because they didn't ask the right way to have it read back to them, the judge said, well, we can't do it because they didn't say the magic words. But the jury doesn't know the magic words because it's a one and done deal in your system. I would know what I know what aggravated assault needs to have done before it goes from assault to aggravated assault, or but a jury doesn't know the magic words you have to ask in a courtroom. So it's kind of stupid to believe that a juror, well, they knew they should do that because you read them 45 minutes of jury instructions where they were sitting there thinking, what if any snow?
So my view on that is probably, but we don't know. And to be clear, I don't think the judge should rule on August 9th, one way or the other. I think what she ought to do is say that there is a legitimate factual question based on what has been presented in front of me to continue the process. I wouldn't grant the motion. I wouldn't deny it. I would say we need more. And if you notice today, one of the things the lawyers did was, Judge, you got to give us permission to talk to the jurors and get to answer some of these questions. They're not asking questions. They're absorbing and sponging and reporting what it is. And the reality is they're asking permission to develop evidence. If they develop more evidence, the judge, the next thing to do would be to order a hearing and bring in the jurors and let them testify, let both sides ask questions, and then you develop a factual record. Then you have legal argument and you go from there. And that, to me, that's what I've always said is the way this should be handled, that there's enough here to continue the process.
Yeah, and as Botting for Truth is talking about, the jury now knows the FBI is there, and how do you think the jury feels now? The problem is the jury is stewing in all of this coverage right now, because now they, of course, they never ever looked anything up during the trial, because they were instructed by Bev not to do it. They have been sitting out here looking at all the evidence now. You need to get them in there as fast as possible.
Yeah. No, if you're going to do it, you have to do it. I mean, you don't do this a year from now. You do it while the iron is hot. That's while it's fresh. Have them explain what it is. But you're right. I mean, they've now been exposed to whatever is public. They know all of this other stuff that's going on. And the longer that goes on, the trickier this process gets to make sure, are they talking just about what happened in the jury room, or are they now being influenced by and consuming all this attention to make them feel even stronger that, you know, there was no evidence of guilt or whatever it is. So I agree with you. The longer this drags on without getting them in, the harder this gets.
Yeah, the less credible all the evidence you get from them, because you will also have those witnesses who's been out there now saying, "Oh, if we agree with that, we have to go. Nope, we were never in alignment. No, we didn't." And this is, when did they file the first one? The 5th of July or something? 8th of July, I think we had the first filing.
Yeah, it was like less than a week after the trial. I mean, it's crazy. Yeah,
and nothing has happened. But that's typical Bev. Let's punt it down the street and maybe something happens.
Well, nothing has happened on many levels. The judge hasn't ruled, obviously, but the most telling thing that hasn't happened is no one has come forward and say it's not true.
Yeah,
we were hung on count 1. We were hung on count 3. All of the evidence so far, whether it come from jurors, intermediaries, as reported by defense lawyers or prosecution people, is that they were, you know, there were verdicts on those 2 counts, but left unanswered is how the hell did that happen? And that's kind of the missing piece here, which ought to be fleshed out. I don't think this is rocket science.
No. If there must be a retrial, the defense should stress the physics and science provided by ARCA's experts more. There was no pedestrian car strike, so how can Lally get past that? Well, he could this time. But I agree. But again,
well,
they now know everything Lally will throw at the table. But Lally now have 3-4 witnesses in clear perjury.
Here's what's going to happen if there's a retrial, and this is why this whole process is untenable for the DA. So, number one, you're never going to see Trooper Paul again. Forget that. Even these people know that was a clown show. That was embarrassing. That leaves the DA with one choice and one choice only. They need to find somebody on the intellectual and gravitas level as the ARCA guys who have the courage to say they're wrong and I can explain to you why. But not only that, they have to not only just disagree with them, they have to be compelling and explain why the ARCA people make no sense. Probably that's not going to happen because, you know, if it's all based on physics and science, it's hard to believe that other people trained in the same way as them are going to contradict them, especially when they're apparently the top of the heap. So I don't know how they're going to get past that. The other problem they're going to have is the feds are going to loosen the protective order, which, if you recall, restricted the defense from even communicating with the ARCA people. They're going to be able to meet with them. They're going to be able to prep them. They're going to be able to ask them questions. They're going to be able to present to them hypotheticals. They're going to be able to say, if this was this and look at this. They're going to be able to know all the cross-examination that Lally did, which, you know, people may roll their eyes and say it's not important, but at least if a couple of jurors thought it's important, they'll throw it at them. They will have access to prepping them. They'll have access to other things. It will be a much smoother presentation and they'll be more prepared. That was a fire drill at trial. I mean, they had the witnesses, but they had no control over them. They were just told, you can talk to them the day you call them to testify. It's going to be very different now. They have a chance to prep them for cross. It's very different, and it's a huge, huge advantage for the defense going forward.
And the also important part, they will be able to see Trooper Paul's testimony.
That's right.
And then they can say, scientifically and stuff rates just below flat Earth theory. We don't use it that much anymore.
Well,
we used it back in the day when we still burned witches.
Again, even if the DA decides to throw out Paul, which they have to, I mean,
yeah,
they can't be this dumb. I mean, we can make jokes about how there's zombies. They just strike, they make you scratch your head. They can't possibly think that that man is qualified for what he testified to, but they're stuck with certain components of his testimony. I mean, what are they going to do? Change their theory? It has to be this, he hit him in the arm when he was tight and pirouetted and somehow landed 20 feet over there. I mean, how are you going to clean that up? You really can't, unless they're just going to say, we don't know. We don't know. The problem they have is the burden of proof. A tie goes to the defense. They have to, in essence, overwhelm the defense theory so that the jury doesn't say, well, maybe I don't know, because maybe I don't know is not guilty. So how are they ever going to?
And that's the funny part is the longer the trial went on and the more we got closer to facts, the weaker the state's case got. We talked about John O'Keefe's death for 2 days from the state side out of 8 weeks. But talk about something. Yeah. Hello, Brandi.
Hey. Hi. How are y'all? Good. Sorry, I'm late. I had to finish with my Chad Dorman thing and then cry my eyes out all by myself for a few minutes before I got on. That one's hard. That one's a hard one to listen to.
Oh.
Yeah, that was
are you hurricaning or are you past all that?
I'm past all that. We only got like the outside of it. So I lost internet for a little bit, but I never even lost power. So now it's like, I mean, it's cloudy out there and stuff, but the storm hit and moved out pretty quick. We were just on the outskirts.
Okay.
So I got lucky.
Yeah, that's nice that you got the easy. I don't understand people living in Florida. It's Australia of America. The wildlife tries to kill you or the weather.
Yeah.
There should just be a big sign on the border saying, nope, God doesn't like this place.
That's why that's why we have a reputation for having crazy people. That's why you hear about like Florida man and, Florida woman and all of the craziness. It's the heat and the weather make everybody go nuts here. And the bath salts, somebody said, yeah, the bath salts too. That was more South Florida. That doesn't count.
Yeah.
Mark Cunningham says, what up, guy? Thank you for all you're doing. Always watch. Thank you so much, Mark. And the jury, did they have a chance to fill out any parts of the jury forms before they ask about the deadlock part?
Don't know.
Well, they were told they had to be unanimous on everything before they could fill it out. So, which they could have believed. So,
these are the questions. This is why they should have testimony from the jurors. I mean, this is not, again, rocket science, and everybody falls on this. Oh, we don't do this with jurors. But this is a whole unique situation. These are jurors who are contacting the defense and the DA on their own. That never happens. It's usually the other way around. Nobody reached out to them, and they're saying, we acquitted. Some people want to understand, how can that be? They didn't check the box. Take the testimony. This is not that complicated.
Mm. What do you think the chances are of her actually polling the jury, or bringing them in to get their answers on this? Because I don't even, especially after her comment with at the last hearing where she said whatever she says she knows is going to be appealed. I was like, okay, well, she's already kind of setting us up to know that she's not going to entertain it.
I don't know. I mean, the pressure is getting more. I mean, the more that comes out that it appears the needle is tilting towards, my God, they really acquitted or tried to, and they didn't know what they were doing. Puts more pressure on her. It puts more pressure on the DA. And I mean, look, do I think they're having ex parte communications? No, I don't. That just means, do I think the judge and the DA are talking without the defense being present? No, but I think that there's kind of an obvious thing in the room here, which is, who's going to get blamed for this? And if you're the judge, you put the pressure on the judge. If she denies this, then she's getting torched publicly, the risk of being appealed, this and that. You know, if you're the judge, you're looking at the DA trying to give them a signal saying, look, forget the law, forget the waiver, forget checking off the slip. It's pretty clear your murder case sucks. Okay.
Yeah.
Like, it's bad. Look at what's going on here. So why don't you take the heat and do the right thing? Put on your big boy pants, Morrissey, you know, put on the 3XLs, get in there and say, we're dismissing the murder case. Because you don't have to say on double jeopardy, saying, you know what, we've reevaluated, we're going to streamline the case, sell it any way you want. But I think the judge would be very grateful if the DA took it off her hands, because this is putting her in a very precarious position. Because if you're going to start getting into semantics and form about whether you waived and whether this, without even hearing from the jurors who were told what to do, they clearly didn't check the box off the way you're supposed to. But, you know, they're not uneducated. I saw this jury, but, you know, one day, this is not a bunch of uneducated people. There's professionals. They're not 21-year-olds staring at the floor. For whatever reason, they didn't do it. Is it all the foreman's fault, foreperson's fault? I don't know. I mean, you really should take the evidence, figure it out, and let the chips fall where they fall. But what ought to be the primary concern here is possibly retrying a woman acquitted of murder for murder again. That's the most, this case has been so embarrassing already for 20 different reasons. Nothing would ever top the idea of retrying an acquitted murder defendant for murder and having a bunch of jurors speak out and say, are we in America or are we in, you know, Stalin's Soviet Union here? What are we doing?
Yeah.
Yeah, and it's just so weird that they, again, as I said before, the DA is not out to get revenge; they're out to get justice. And when the jury clearly reached out to them as well, they should also be sitting there and say, "Well, we probably got it wrong." So can troopers
should?
Well,
yeah,
should. You get to this thing. So the DA's last response primarily did two things, right? The first thing they did was wrap themselves in ethical, righteous indignation about, we're not going to ask questions because we don't want to violate the rules, which is also a backhanded dig at the defense, who they're claiming is doing something they shouldn't be doing. And then they did say, you know, and plus we can't guarantee that you'll remain anonymous, which, by the way, I don't think that's doxing them. I don't think it's threatening them, but it's letting them know what everybody already knows, which is the jurors don't want to be outed. They don't want to talk about this publicly. They don't want to be part of the story. And, you know, a funny thing happened after the DA told them, I can't guarantee you remaining anonymous. They stopped communicating with them. So, and the other, and the real thing about their response is, why was it sent in at all? They got outed by the press. That's the only reason they sent that response. If Christina Rex didn't do that, very good reporting, by the way, they don't make that response.
Yeah.
They don't submit that at all.
No, and that's, again, it just shows, if I did a stream a couple of days ago where we were sitting here talking about it, said, when we started, it was me, Turtle Boy, the Glarer. Brandi only had her podcast. You weren't really doing live streams in the beginning. And Young Jerks and I believe LTL in the beginning. So we had like maybe a combined 10, 15,000 people watching. So they didn't care back then. But when this case blew up and you get EDB, you get Burkhardt on it, all of a sudden it's a couple of 100,000 people who watch this trial and watch how bad it is. And I don't know many streamers who went into it thinking, well, let's wait for the evidence, who came out of it saying, nope, she's clearly guilty. Everyone who saw that trial and is not a massive idiot could see this trial was, it should never have been brought, at least not with these charges. Could you have said it's a DUI hit and run? You probably could, kind of, maybe, even though the body doesn't match up with it. But you could probably, but murder, it's that upcharge was so crazy just to try and force her to get a conviction. It's so stupid.
Yeah.
It
Or to
is.
get a plea.
It is stupid. It's also, I don't know why they ever thought that was gonna do anything. I mean, Karen Reed is not your common defendant. Okay, you don't usually have a well-educated, financially successful female, okay, who is alleged of murdering her police officer boyfriend. The idea that somebody from her social standing, and this is not meant to be a class thing, this is how the criminal justice system works, that somebody with the resources that she was going to have, the ability to fight, a lot at stake, was somehow just going to roll over and plead guilty and walk into a prison cell. How they ever thought that that would happen that's actually mind-boggling to me. I don't think that was ever on the table. Why they
Yeah.
would think
No.
that is mind-boggling.
No, and again, imagine if that's what I'm always saying. This is showing you how bad that crackhead down the street has it in the justice system.
Yeah.
Yeah.
Because they will just say, hey, you can get 5 years or you can get 15 years. I'll plead.
Happens all the time, every day. I dealt with something similar to that this morning. Not exactly that, but there are times where, a plea makes sense based upon a number of considerations, and you cut the best deal that you can. I got a very good outcome for somebody today, but he was guilty of, some bad things. So you work the best angle you can. I thought it was a very good outcome, and that's a win if you judge it in that way. But when somebody still walks into a prison cell for 7 years, is that a win? Other things being equal, maybe not. But the idea that she was walking into a jail cell, look, she hired real lawyers immediately. She got bailed out immediately. She wasn't pleading guilty. On top of the fact that her position has been contrary to what a lot of the screamers and yellers and trolls and whatever they are saying, her position has been, I didn't do this. Notwithstanding, all this spin about she admitted this, she admitted that, she told her parents this, all that nonsense. Her position has been quite early, I didn't do this.
Yeah.
And she has a right to defend herself. And why people equate her exercising her right to dispute and put the burden, put the prosecution to their burden, why that translates to she's evil, and anybody who supports the contention of the way the American justice system works, which is you have to prove her guilt beyond a reasonable doubt, and every single defendant has a right to challenge that. Why that makes, people like me, I'm just a lawyer analyzing this from a legal standpoint, it makes you a bad person because you say, yeah, that's how the system works. And oh, by the way, in looking at the case kind of stinks. That's not disrespectful to the man who was killed. That's looking at this as, burdens of proof, and why that triggers all of these people is beyond me. This is no different than any other case that happens in an American courtroom all the time.
Yeah.
Yeah.
Yeah. That is something that's very interesting to me on this one, because it is, with other cases, I've always been able to look at the evidence and discuss the evidence and discuss, is this a good case? Is this not? What do they have a chance of proving? What supports it? What goes against it? And it just is what it is. On this one, it's your entire character and who you are as a person is attacked by discussing evidence, and,
which tells you something's wrong here, and this whole thing stinks from its core. And a perfect example is even within the case. And you go back to Proctor. I mean, his whole attempt to explain the text was, I was really upset, and I shame on me, but I just emotionally lost it. And I was talking last night on another stream about this, and you don't want to be disrespectful to any murder case because they're all bad. I mean, somebody died who didn't deserve to die, and John O'Keefe didn't deserve to die. I think everyone can agree on that. But when you are a hard-boiled or a hardened detective, you deal with the business of murder and horrible crimes, and that's the way it is. And for world of homicide cases, again, I want to be delicate with this, but it's an important point. Somebody getting probably accidental or even on purpose hit by a car and ending up deceased in the annals of emotional murder is very low in terms of
Mhm.
affecting a detective, as opposed to a baby getting stabbed in the neck. Okay. Or what you saw in England last week with those
Yeah.
children. Okay. That is the kind of thing in the annals of murder that the most hard-boiled detectives would say, I need time. I mean, anybody.
Mhm.
I mean, what that thing with those little kids in England is horrifying. But his whole explanation about his text messages against Karen Reed were, I was so upset 8 months later, by the way. And that's just another example of it makes no sense. It's a lie. It's not true. That was almost certainly perjurious. God knows what other messages he sent on other cases, because if that case bothered you, you'd think the other ones did as well. And by the same logic, you must have been upset. But the point is, why are all of these people, whether they be the lead investigator or people who just think for whatever reason that Karen Reed is guilty, and maybe people like, I don't think she's guilty. I don't care that other people think she is, but that doesn't make this some kind of hatred between people. I go through this every day professionally. People agree or disagree. This is on a lawyer level, this is sporting at some point. I mean, you're jousting, you're arguing, it's an adversarial system. I don't know why so many people who think Karen Reed is guilty, notwithstanding my view of their opinion, which I think is a little out there, why there is so much nastiness and hatred and delusion that associates with it. And to me, it's all, well, somebody's saying it's because they hate certain people involved. That's true. Um, there's just something so off with this particular case and the people who follow it. It's crazy.
I think I replied to you on Twitter with something. I said, it's funny how the other side has nothing but hate.
Yeah.
Brandi,
No,
I missed you, girl.
no, my
You
God.
have gotten so much shit spilled all over you,
Yeah.
and sadly also from our side, because there's so much emotion in this case, and at least we can meet, we can agree, we can disagree about things, because I think all of us are 18 and grown-ups and have been through one or two knocks in life and believe that you can agree and disagree. Everyone is always out there trying to make everything into an echo chamber, and especially the other side. Well, you must believe this, you must believe that. She did say, I hit him, I hit him, I hit him. When? Yeah, the 20th time someone asked Jen. And Tom CPU, I didn't forget you. You were on the golf course when I sent out links. So just so I don't get shit on. But oh, he didn't invite Tom. But you were playing golf, and I thought you are having fun more than we have. And Sarah has been asking a few times, can the troopers be called like Proctor Bukaknik? We know both of them are involved in two other cases. They
What do you mean called? I'm not sure I understand the question.
They can be called back to testify.
Well, they can be. I mean, look, if you're the prosecution and you call Proctor, at that point, you're not going to be calling, Trooper Michael Proctor. You're going to be calling Michael Proctor.
Right.
And he gets cross-examined. I mean, like someone like me would cross-examine him. I'm not calling him Trooper. You're Mr. Proctor. Okay.
Mhm.
Because you were terminated. He will be by then. You're a disgrace. You're this. So if they want to enter that, that's the problem they're going to have. Now, the defense can certainly call them if they want to, and I imagine they would. I mean, if the prosecution is going to retry the case, you're going to twist the knife and make it hurt. And the reality is, if the DA does not call these troopers, just to go back to something earlier, these two in particular, then where's the taillight coming from? Where are the 45 pieces of taillight coming from? And if they don't call them, and they don't call Berkowitz like they didn't, and they don't call Tully because he's in trouble too, right? Maybe he won't be by then. I don't know what's going to happen. I mean, can you imagine the defense summing up saying they don't call the lead investigator, They don't call his supervisor and partner who did all these interviews. They don't call their supervisor who managed the CERT team, and yet they want you to believe this. I
Yeah.
mean, this is why I just can't fathom, with the benefit of time, that this is going to get retried.
No, as I
just-
said, it was the World Series. It was the one at bat they had to get it out of the park, because the defense will be stronger the next time around, and the state will be weaker.
Yes.
Yeah.
Nothing
agree.
will get better for the state the next time at bat. They will have lost at least one witness, maybe 3 witnesses will be gone from the illustrious blue line that they could hide behind.
What?
They will go really deep into Jen McCabe's, because a lot of people have been doing the timelines with her. Imagine when they have it written down and can say, but you lied about this, you lied about this, and you lied about that. And now you know she was at the house at 12:36. Do you still say she was outside of the house at 12:54? You have her perjuring herself so many times. And you have I think the best card is you'll have the ARCA guys in there you can spitball with and say, okay,
Yeah.
we need a little more of this, we need a little less of that. And again, it becomes moist o'clock whenever I mention Mr. Cannon. So the ladies will love him again the next time.
The only thing that'll get better for the DA at a retrial is, again, addition by subtraction. There's no Trooper Paul. So, that actually helps them, because that was embarrassing. The other thing that's going to happen, again, you have these 2 really talented lawyers who are going to scratch their heads, look at the transcripts, do all this. How do we do this? I think what you're going to find is that in their summation, that they get more into the weeds of the actual evidence that discredits the case, as opposed to a more broad stroke, because it's still going to be a long trial, not as long as it would be as a murder trial the first time around. But I think one of the things that they would do differently is really get more into the weeds on why these people are not credible, and pound that into the jurors' heads, and do things like that, and use the ARCA stuff to lead to the Taillight, which leads to Proctor, and just kind of connect those dots. And at some point, this is only going to end one way. I mean, there's just, I don't see any scenario under which Karen Reed's ever going to get convicted of anything.
No.
Yeah.
What will happen if some of the witnesses come forward and say they testified falsely? Well, then you need a hearing.
Well, I mean, if those witnesses, if I assume they mean prosecution witnesses, not sure why they would do that. You could potentially be exposing yourself to prosecution. You're still within the statute. But even if that didn't happen, that would just further kneecap the prosecution case. I mean, they certainly would not be prosecution witnesses going forward. And I guess it would have to matter how important a witness is it, and are any of these people, some people speculate that some of these witnesses are cooperating with the feds. I don't necessarily believe that, because why would they have testified 2 months ago and perjure themselves to cooperate now? You damaged yourself much worse. So I think we'll just have to wait and see.
And again, as long as they toe the line of the DA's office, even if they are blatantly lying, no charges will be brought against them, because it's the DA's office who will charge them with perjury. So
clearly no state charges would come, right? And the feds are not charging standalone perjury charges unless it is somehow related into the larger problem. I mean, if, I'm making this up, I'm not accusing anyone of anything, but if they were already had their clutches in someone like Higgins for a bunch of stuff, and he then lied in the state murder trial, could they add that as part of his stuff? Yeah, sure they could. But they're not going to, you're right. They would never just bring standalone perjury charges against someone.
No, but that was one of those things everyone was talking about during the trial. Oh, perjury. Doesn't matter, because who files perjury charges? The people they lied on behalf of. So it doesn't matter.
I mean, one could argue there's a conflict. Do you need a special prosecutor? It gets complicated, but I agree with you. Generally, the idea that anyone is going to get prosecuted in state court for perjuring themselves in this trial is pretty low.
And B says juries didn't check the box. Are we morons in Massachusetts? It was hard to read that jury instruction, in my opinion.
Yeah. And, it specifically said, too, I put this in the last podcast episode when I was putting all this stuff together. It specifically, the way that it was worded specifically said, once you have come to a unanimous decision on all 3 counts, then check the jury box. So, or jury boxes or whatever. So it's like, if you never get to that unanimous on all 3, you never get to that next step. So I think that while they were saying we're deadlocked and need clarification on where to go from here, it turned into, we never made it to the boxes because we never agreed on all 3.
This is why you need a hearing to explain these issues, because contrary to what the DA was arguing about, oh, they didn't check the box, they didn't do this. This is not necessarily after the fact regret, and I should have done this. Their whole argument, at least as it's been submitted in the affidavits, is we had a fundamental misunderstanding. There was not a meeting of the minds between the jury instructions from the judge and what we did, and that affected our ability to do this. Now, it's totally a fair question to say, well, why didn't you ask? And the judge would have to assess whether that shows that they're just having regret or did they truly acquit. But a good faith basis exists here to have a hearing. Do it.
Yeah.
You're trying somebody twice for acquitted crimes. Stop the form and focus on the substance.
Because if it's not true, you're going to have at least one say it's not. All it takes is one to be like, no, I that's not what I said. So what does it hurt if, just to find out if justice is the true, goal here, why not?
Somebody should ask the foreperson, why didn't you check the damn box? And let's hear what he says. And maybe his answer stinks. I don't know. But we don't know.
And Bossing for Truth said, what do you think the jury feels about the FBI involved?
I'm sure they feel, a little bamboozled. But on the other hand, they're not supposed to know. They're not supposed to have, extraneous, prejudicial thoughts in their head at the time that they're considering someone's guilt or non-guilt. And it's larger than Karen Reed. That's the right ruling. You don't want jurors getting prejudiced by things that are, extrajudicial, as what lawyers call them, outside the actual courtroom. But having said that, now that it's over and they say, oh my God, the feds are looking at this, they're looking at that. And the feds are the ones who hired, the ARCA guys. Yeah, I'm sure it makes them feel like, Jesus, this is crazy.
This is bigger than we just thought when we sat in there.
Right.
Can the defense take it higher than Judge Bev?
Yeah, I think they can. I had to do a little follow-up on that because the Massachusetts rules are really a mess. So the rule of criminal procedure that talks about interlocutory appeals in Massachusetts apparently does not allow it in this situation. But in talking to some experienced Massachusetts lawyers, if you wrap it up in the Constitution, you can make an argument, you can get it to an appellate court because of what the issue is before. So I think the judge was correct in saying, if I do rule on this, the losing party has a right to have a higher court hear it. So yes.
Yeah, and will she punt it again with all of this coming out? Or will she just rule it doesn't got them? What's your you don't know it. What's your gut feeling?
My gut feeling is I hope she takes the middle ground, which is the correct ground, which says, let's develop further evidence and go from there. The next logical thing is I need the jurors, or I need to grant the defense and the prosecution the ability to speak to the jurors. Do you notice how in the defense affidavit today, or the defense motion, they said, Your Honor, please give us permission to speak to the jurors? What didn't the DA do in theirs? Okay. They were told by a juror, we acquitted. We said, oh, we're not allowed to talk to you. But what didn't they do? They didn't say to the judge, can we speak to them? Because we're curious too. Because they're not curious. They just want to bury their head in the sands and hope this goes away. So I'm hoping what the judge will do is say, we need to take more evidence and make August 9th maybe less sexy than people want. But the right legal move here, I believe, is to say we need a good faith basis has been made. Let's allow the gathering of more evidence and go from there. Don't have to
Yeah.
worry about a trial date yet, but I want to do the right thing. I don't want her getting retried for an acquitted charge. And if she wasn't acquitted, then if you want to retry her, even though all the jurors are telling you your case stinks, then do what you're going to do.
Yeah.
And if you want someone who's also really, really good at explaining all the difficult stuff, follow Microdots. It's they have done a lot of good, easy to understand videos because it's really hard sometimes to try and imagine how the state believed John was hit because it made no sense. So Microdots have all the videos you need to kind of understand this case a little better.
The only
But,
question I have about that incredible video that was put up maybe last week, where kind of like the house and what happened, and I mean, real chilling video, really good video. But this is kind of a tongue in cheek. Where did the Bush beer come from in that video? maybe we can get an answer in the comments. I know the man himself is here, but where did we get the Bush beer?
Traded in the White Claw for.
Yeah.
Well, they didn't have any Scots at the house, so Higgins had to go to work and move cars.
Oh, there you go.
I actually
That's
thought,
stupid.
it's interesting in watching that video how there was an editorial speculation that Higgins went to the precinct, in fact, not to move cars like he said, but to monitor the dispatch.
Yeah.
That makes a hell of a lot of sense. I thought that was a very strong, speculative, admittedly, theory. And then they played the call about what could have happened in those 20 seconds. But that's a really good theory about why this guy would, he's pushing John O'Keefe. Are you coming to the house? That shows Higgins wants to go to the house and he wants John O'Keefe to go, and then he's gone 10 minutes later to go move cars. That makes no sense.
Yeah.
And again,
nothing about his stuff made sense. Nothing about anything not the timeline, not the explanations, nothing about his stuff made sense.
Nothing. And the irony, if that's the right word, maybe it's not. You heard a lot of defense theories about what happened in the house that could have led this. And, look, whether it was Colin and the knuckles and he's a hothead, and whether it was Brian Albert, he's a hothead. The reality is, and those are fair theories and whatever, but from an evidentiary standpoint, not that there's, devastating evidence against anyone in the house of anybody doing anything. But if you had to pick someone that there's more evidence against anyone else, it's Higgins.
Yeah.
Based on, the kiss, the jealousy, are you coming? Again, that's not proof of anything, but that's not inconsistent with building up to, the argument in the bar where he's pointing in that direction. That's something.
Yeah.
No,
I said the same thing last week when I was, when I did Turtle Boy show, I said the same thing. Higgins is the looking at everything just from an evidentiary standpoint. Higgins is the main one who my attention goes to, because he's the main one that I have so many questions on, and so many things that don't make sense. And when puzzle pieces are not fitting at all, and so many things are not working with what everybody else has said, that's the stuff that raises my, curiosity.
I agree. And not to get all Columbo on, but as I've said this before, that's my favorite TV show of all time. But if you know Columbo like I do, it's like little things, okay, that always lead to the bigger things. And one of the little things about Higgins that I found fascinating, in that text message he sent to John O'Keefe, "Are you coming here?" or whatever it was, wasn't that followed by several question marks? Multiple. Yes. Okay.
Yeah.
Isn't that an emphasis on, are you coming? That's not just are you coming? That's, are you coming? It
implies emotion. Yeah.
I want you here. Why would he want him here so bad?
When I watched this case, I have been, because I didn't want to buy in. I always said prior to the case start, I said, let's just make it simple. It's a slip and fall. It's no one did anything. There was no conspiracy. It's a slip and fall. That just happened. Boom, boom. It'll make it clean. It'll make it easy. When I watched Higgins on the stand, I started believing Yeah, especially when I watched the video after, because I didn't see it in when we were shown the bar video from the waterfall. But that I've
Hmm.
seen that in a lot of fights I've been in just before it happened.
Sure. I
Yeah.
can't think that this was an accident for the obvious reasons. And I don't know who did what. And I mean, to be clear, they didn't prove anything in the house in terms of what happened. And how could you, unless somebody gives you what you need? But to me, you just can't avert your eyes to the aftermath. And
Hmm.
all of these messages over the next several days, they make no sense. I mean, that is covering up something. Doesn't
Yeah.
mean murder, but that's not normal behavior by people who wanted a party with this guy, and he just ends up dead on the front lawn in a slip and fall with one shoe. And a mixture of three men's blood on his pants, vomit on his face, and everything that you've been through, and all this taillight lying on the grass or snow. It
Yeah,
doesn't.
and they order a tow truck before they ever see the car because they knew it was the car without seeing the broken tail light. There's so much that just doesn't make sense. Mr. Meathook is asking, you always seem to be giving the prosecution and canon the benefit of the doubt. Are you just being differential, professional to the court, or have you been out of Massachusetts too long to remember all the corruption?
Okay, so let's recap the last few months. I have repeatedly called the Norfolk DA's office zombies. I have repeatedly suggested that Michael Morrissey engaged in highly unethical conduct in giving a press conference, that he violated the ethical rules by bringing a case for which he knows legally there's no probable cause. I have said that Adam Lally, on a serious case, is the worst prosecuting attorney I've ever seen in terms of his presentation in court. I have suggested that he may very well have knowingly presented false evidence in this case, although I don't know that. It's hard for me to believe how I've been deferential. I mean, on the other hand, you can't just assume every little thing they do, every action is corrupt. But I'm not getting any Christmas cards from anyone in the Norfolk this year.
No.
As far as the judge, I don't know that she's corrupt. It's just she's a prosecution judge. I mean, I'll be honest with you. If you do this for a living, Judge Canoni isn't that unique in her mannerisms, demeanor, and rulings. I mean, it's kind of shocking, I think, for a lot of people maybe who don't, see this on a regular basis, but she would fit perfectly in Manhattan Supreme Court. There's plenty of people who just are like that. I don't agree with a lot of things that she did, but I'm just telling it like it is. I haven't seen any actual evidence that she's corrupt. She's made rulings I think are terrible, but I think people sometimes see goblins in windows that get a little too carried away. I don't think, when she picked juror number 1, for example, to be the foreperson, I don't know that that's a corrupt act. Now, if Massachusetts law allows you for the judge to pick the foreperson, I think that's weird. I don't know why they do it that way, but if you do it that way, if you said who should be the foreperson, it should be juror number 1. In New York, juror number 1 always the foreperson. There's no evidence that was a corrupt act. I don't know. People can agree or disagree.
Yeah, but
I
that's the same with the plant theory, that they planted people in the jury. There was 150 people going through. It's so hard to, how it is to pick a jury.
Listen. I don't consider myself part of like a movement or a team. I think Karen Reed is absolutely not guilty and almost certainly factually innocent. But that's not because I want to wave the flag. That's just what I think based on what I'm seeing. But, for the people who are really like supporters, like, I mean, literally, you do yourself a discredit if you see a goblin in every window and think everything is corrupt. And you don't want to be like the people who think on the other side, who have no credibility. That's why they have no credibility. The judge is not necessarily a good judge for the defense. I get it, but that's not unique. And I have, to this day, maybe I'm wrong, and I'm happy to have this discussion, but I have not seen a bona fide, guaranteed corrupt act. I just think she's not a great judge for the defense. But I didn't like the way
Yeah.
she yelled at Karen that one time, saying, "You think this is funny?" That's not corrupt. She was having a bad day and was moody, and regrettably, she should not have done that. That looked very unjudicious, but that's not a corrupt act. That's not literally, there are things that she kept out of evidence. There are things that she let into evidence. That's what trials are.
Yeah, and I think if you're new to trial watching, you will think she's a unicorn, but she's not. Brandi and I have seen judges who is worse, better. Just to go watch the Young Thug trial, they had to
Yeah.
remove the judge because he had ex parte meetings with the state. So,
But that's a corrupt act. That's
Yeah.
that's by definition inappropriate. But the fact that a lot of people think that this judge doesn't have, she's kind of moody and snippy and snaps and whatever, that does not necessarily translate to corrupt. Okay, there are plenty of judges who are moody or whatnot. It doesn't mean that they're corrupt. Now, I'm not trying to hold her bag or hold her gavel. I'm just saying I don't know literally what is corrupt. And just because she makes a wrong ruling doesn't mean she's corrupt either. Like, for example, I thought her ruling in the trial about allowing the McCabe's and Alberts to claiming that the door had been opened to the harassment that they suffered was a terrible, terrible, wrong ruling. Do I think that means that she was corrupt? No. I mean, could she have been? I guess, if some people think that was on purpose. I don't know. But you can make terrible rulings and not be corrupt. I think you just have to be careful throwing around everyone's corrupt. That's all.
and
I think with her not. Go ahead.
No, I was just saying it's also that problem that you want to make everything part of a big conspiracy. It can't just be someone is an idiot. Most of the time, people are just stupid.
Yeah,
that's right. I mean, it doesn't have to be mutually exclusive and being, an idiot and being corrupt. You can be both, or you can be one, or you can be neither. They don't have to go together. It doesn't mean that she's a great judge for the defense. And, the reality is, and I said this back then too, you know what? Mike Rodot's literally read my mind. Literally, I was just getting to this, and then he popped that up. That's creepy, because what I was about to say literally is one of the things that really pissed me off that she should have done, and I said it back then, was when the inverted video came out, and you can find, I don't know who I said this to, was I hope the next day, before the jury comes out, that the judge, in the presence of the lawyers, says, "What the hell happened in my courtroom yesterday?
yeah.
I need to know." And, I want to hear from the parties and the defense. I mean, I would be seeking sanctions. I'd be seeking potentially mistrials. And I really was hoping that she would be pissed off about the DA either perpetrating a fraud in her courtroom, or at least explaining themselves about how, in the case of the century in Massachusetts, you idiots could have literally introduced this like it's not a problem and think that that's okay. And she didn't do it. And I think that was terrible. I think she did a lot of things that were terrible. It doesn't make her corrupt. It may.
I think that with her not recusing herself too, and then not allowing for the trial to be continued, and then there were so many things before the trial even started, on top of her being snippy with the defense on different things. I think that because of all of that stuff, with emotions running so high on this anyway, it kind of put that cloud of now everything that she does is being, looked at more intensely than it maybe would have without all of that stuff.
That's a really good point. And now, in all fairness, so I wasn't around during the, famous, Auntie Bev and the text messages. I to this day, I don't even know. I mean, I know the cottage on the Cape. That I don't know that full story. That's problematic if there's a potential relationship and there's an appearance of impropriety or relationship, and whether she should have recused herself or not, the safer course would have been yes. I agree with you. But I think what you just said, Brandi, is really good. That colors your view. At that point, everyone's saying, what's going on here? Something stinks. And that's a really good point, because I didn't see that. I didn't know about that. And might that have made me feel worse coming in knowing, my God, she had a relationship, renting a house or whatever with some of these people, and why is this not a big deal? Maybe. But I don't really know a lot about that. So, but I mean, I know the issue with, her father and Chris Albert or whatever. That's a little less, I mean, that's not great either, but that's a fair point. I mean, it really could color your lens before you see what's going on and put it in a worse context. That's fair.
Michelle says, don't feel bad. Even though you were left off the official grifter list, you are now grifting by association with attorney Bederow on your show. Well, that's why I got Brandi on,
I was
because
going to say, she controls the updated list. You're good.
Yeah.
I do. I added you.
Michael asks, isn't it worrisome that the jury thought that maybe Karen hit him and didn't know if that would mean that they didn't buy the theory that Proctor planted evidence, which is crazy?
Yes. Worrisome? No. Mind-boggling? Yes. It's not worrisome because, notwithstanding a lot of people who are running around saying, oh my God, 9-3, that's good for the prosecution. No, it's not. That's 3. You're missing 3. You got to get 12. Okay.
Yeah.
And I know 9-3 is better than 11-1 against you, but how the hell are you getting 3 more people to say, come over here with that? And you actually, the fact that you got 9 is stunning because if she's guilty.
Well, they had the bullying session, as we read today.
That's
They
right.
had to beat 3 people to make them switch sides.
And
Yeah.
they couldn't get the other 3. And that's a
Yeah.
fair point too. But the point is the idea that anybody who wanted to find her guilty of anything would have had to accept the fact that beyond a reasonable doubt, she had to have hit him in a car, whether she meant it or not. And I think it necessarily translates that you would then have to believe that she hit him hard enough to shatter a polycarbonate taillight in the way that it was found. And you'd have to believe that the injuries to him were consistent. You'd have to believe that he could have ended up in the middle of the lawn with one shoe on because of that impact. So yeah, is that worrisome? No, I just find it hard to believe that anybody who followed the credible evidence, especially when you're relying upon Michael Proctor as the key witness to support what happened. And I'm not even talking about the text messages. I mean, there are things that he did and said which are stunning. And, I would hope if Proctor were a witness at a retrial, that one of the other things the defense would focus on, they grilled him to no end on his tunnel vision and how he had the blinders on to, I'm going to, pin it on the girl, as he said, not the cop. He's good. All that. He ordered a tow truck before he ever went down there. How that wasn't a bigger deal is beyond me. That is literally, in my mind, compelling proof that the fix was in his mind. But then he gets down there and never photographs the shattered taillight that he claims happened, even though the local cop who beat him to the scene said, yeah, it was a little crack.
Yeah, but that's again, don't tell me that Janetti and AJ doesn't also go around and look at different chats and says, oh, this worked, this didn't work. Okay, we have to switch up. They are sitting at the wedding stone, making this knife sharper for the next attack.
One of the best parts of being skilled lawyers like they are and being top of the profession and knowing that you are, okay, you're not insecure, okay? So you know what? People come up with good ideas. They're good enough and confident enough and comfortable enough in their own skin to say, that's a great idea. They're not sitting up there saying, who the hell are you? Non-lawyers, true. Okay. Facts are facts. Evidence is evidence. Ideas that are good are good. And when you're at a certain level, you're confident and comfortable enough to say, that's a good idea. So they see some of these good things coming from people online. You don't have to reinvent the wheel. You take it, you go with it. They're not.
Yep. Because you're lawyers. You went to school. You speak the same language.
Yeah.
Brandi and I,
jurors.
We're two nobodies, like the 12 people you'll have to sell it for. So if we're sitting here and say, I really don't get how they believe that Chloe got to his arm, because we know she was in the bedroom. Okay, we have to focus on Chloe. Tell if they want to use. I'm just spitballing things here. I believe the Apple Watch. Okay, we need another expert to tell us about the Apple Watch. We need microdots to show us that the Apple Watch actually could have been in the house, because that circle, it was a little hard to understand that it was everywhere in the circle. It's not in the middle, because humans normally see patterns and we put things in the middle of a circle.
Well, I think again, the benefit of time, and these guys know what they're doing. My suspicion would be that you reach out to Apple directly and you try to get an idea of how steps and stairs work. And, I wear an Apple Watch 24 hours a day when it's not charging. Probably 80% of the people here do. And, we all have like step goals and stair goals. And sometimes you're like, oh God, I just went up 10 flights of stairs. Where the hell are my stairs? And eventually they catch up. And there are times where if you're walking up a steep incline, you might get credit for that as a stair. But the way it was testified to, the guy's sitting in a car.
Yeah.
You're not getting stairs, but my understanding for that, and I would hope that they would go to Apple and get an answer on that. That's my dog having a crazy dream in the background, if you can hear that. That's loud. Jeez, look.
But when they talked about that, that reminded me. I don't know if any of you ever played that Pokemon Go thingy where people ran around and with their phones.
Yes.
Yeah. I had a buddy of mine in Australia. He figured out the exact speed he should drive his car so it believed he was walking, because it had a pedometer, because it was made to make you more active. So he figured out, if I just roll my car at 3 miles per hour or something like that, it'll think I'm walking.
Right.
But your car or your watch isn't that stupid. It's a smartwatch. It's smarter than most people. So it's such a stupid excuse that, well, she was driving up and down the road.
You are not getting stairs, riding in a car, going over very mild hills. Okay. No one is suggesting these are like the hills in San Francisco that you see like that. This is a slow incline. And if you've been in that area, you know exactly what they're talking about. That sounded like ridiculous testimony, trying to justify what it was. And, I wouldn't be surprised if there's I don't know what the expert would say, but would you be surprised if they had someone from Apple who comes in and says it doesn't work that way?
Well, in the Murdoch trial, they just put an officer in a room and he sat and threw it around for a weekend and he couldn't tell you how he figured it out. He just tossed it. And that went in as evidence. Sometimes it does sound smart.
I'd feel better about it if you said, John O'Keefe was sitting in the car, jumping up and down, going like this, trying to.
Yeah, they were fighting, so he was waving his arms around, probably.
That's embarrassing. I mean, that's ridiculous. I think that's ridiculous. Wearing an Apple Watch for years.
Yeah,
I'm no expert on the technology.
No, you can't cheat it. It's such a stupid watch. I can't sit here and get my 10,000 steps in. Yeah, I have to. Yeah. Was it hard to see the TV in the courtroom? Yes, everyone has said that.
Very, very. And where we were sitting, which is kind of behind the defense, is actually closer than the jurors. And it's hard to see. You can't read. You can see like video and whatnot, but if there was text, you could barely even read it, if you could at all.
Could they rewatch them, or wasn't it allowed, like the readbacks?
Could they what?
Rewatch it in the deliberation room.
The videos they could. He said that in closing, because he told them to go watch that one of them leaving waterfall.
Yeah, I mean, evidence is evidence. If it's in evidence, they can. Yeah.
Isn't the fact that so many MST and Canton PDs are on an investigation favorable to Karen's case? Yeah, I think we agree that Proctor being fired is a good thing.
Yeah, I mean, that's big yes with a capital Y.
Some chatter earlier stated that the DA's office received the juror's email before they made public statement. Defense claims had no merit. Is that true? Well, it's kind of true, and well, because the legal merit of the request could be, maybe, as far as I understand it, it's not sure that the legal merit is there to call the jury back in and ask questions. I'm going to assume
the answer to this question is no, only because if they submitted their first response knowing, belittling, laughing at the defense conjecture and all this, knowing that there was evidence, I think by now the defense would have absolutely unloaded on them in a reply filing. So without knowing what's going on behind the curtain, I'm going to guess from an educated professional standpoint that probably not. Because they wouldn't hold
I
back.
think they got the first letter the 6th, and I think that Yannetti talked about the 4th. So I actually think they had it before. But I would have to go and look up the filings.
That would
The
be really
6th
disturbing if they did that.
The 16th is the first day that Lally had listed in his filing from last week. I think the 16th was the first time that he had that was the first date that somebody had contacted him. I think that was one of the emails that he got was on the 16th.
After the reply, they submitted laughing at this, though.
Oh,
Yeah.
I thought it was the 6th. So yeah.
Oh, I thought it was 16th.
I'm not.
Let me look. I'll pull it up.
Yeah, you have all the receipts. Should someone tell me about the duffel
Always.
bag? I'm confused. Which duffel bag? Now I'm confused.
I don't know what that means.
We agree. We are all confused. Matilda says, "Good evening from the Netherlands."
Huh?
Good evening, Matilda. That's normally the name of the Dutch queen, I believe. Linda asks, "How will the Commonwealth call back Proctor, Tully, Bukaki? Will they won't call Proctor back. Tully will probably have to do it. Bukaki, again,
We don't know how much in trouble. I mean, they're under investigation. That doesn't mean that they've been found doing anything terrible. So they may be okay by then. Proctor is a problem. On the other hand, Proctor did a lot of things that are important to the case. And, even if they don't call him, if you call Buchanan, obviously the defense is going to say, who was the case manager, if that's the word we're using, and who was with you at every step. And it's going to be Proctor. Proctor, do you know where he is today? Objection. I mean, this is a mess either way. They are in a lot of trouble with the mess that Proctor has created and potentially with these other guys.
and we have Lefty saying this team really need Doink the Clown. I miss Doink. His mother Wendy Murphy has really been out saying stuff that made me think, well, Grant didn't get it from a stranger. Jesus, she's an idiot. It just shows you law school isn't that hard.
They are very embarrassing for this profession, both as admitted attorney and student.
And Max says, by this point, if I was a juror, I had to stand up until the issue was with the form. It doesn't matter to me. McAlbert doesn't scare me. I don't understand. Number 2. Well, they did, because they went to a journalist and confirmed what they were saying. At least that juror did, and said, I can see she's being railroaded. I need this out there because the court doesn't take it. They just put a gag order on the witness list. So that's why I think they reached out to, what's her name, Liz, or what, the journalist who broke that story. Oh,
Christina Rex.
Yeah, Rex. Yeah, because they wanted it out there, and that sent the snowball rolling, because then you got the admission from Lally's office that, oh, by the way, we did hear about this. Mark, will the defense be able to request the FBI named versus in another proceeding? No. I can answer that one for you.
It's the same analysis as before. It could be heavily prejudicial, so probably not.
Yeah. And Stephanie, thank you so much for 10 gifted memberships. Can current jurors be witnesses in another trial?
No.
If it has.
I mean, if they witness a crime unrelated to this, I mean, yeah, if you're a juror, in this case, and 6 months later, you walk down the street and see a robbery, yeah, you could be a witness, but you can't be a witness in this case about anything that happened at the first trial.
No, you can't call a former witness and say, "Hey, what did you read the last time, and why didn't you believe it was murder?"
No.
That kind of takes it, because the witnesses in the retrial will be the finder of the facts in that trial.
Okay,
Also,
I just
thank
double
you,
checked.
Brandi, for watching.
Oh, sorry. Hi, Jamie. July 16th is the day of the email, and July 13th is the day that he had sent that response about how it was all
Fungus.
ridiculous. And yeah.
All right.
Okay,
So,
yeah. Well, so he's on the home free for that one.
well, let's criticize him for something else. He shouldn't be criticized for literally concealing what he knew. He should be criticized for failing good lawyer 101, which is when you get a response and you don't have any information in front of you, you shouldn't be rambling on with all kinds of histrionics about this is ridiculous, this is wrong, none of this makes any sense. It turns out there's a lot of credibility to the argument. So maybe take a more even approach and say there's no proof as of yet, as opposed to this is all conjecture and this and that. It wasn't conjecture. They were submitting sworn statements from credible lawyers saying this is what I was told. That's not conjecture. You may not find it admissible evidence. You may not agree with it, but they're not making that up. That's not speculative. That's a juror telling them.
Wait, hold on. I want to clarify one thing. The emails, it doesn't have the date of the first emails. It only has, hold on, let me double check and make sure. Seat number. Okay, 21st and the 26th were the voicemails. The Commonwealth received emails from 3 individuals who want to speak anonymously. Yeah, they actually, so I don't know when they had it, because in this document, it does not say the date of the first email. So maybe, I don't know when the first one was.
So they identified the date of the phone call, but did not identify the dates of the emails.
Yeah, I'd be curious to see. Ooh, FOIA request.
That's
Yes.
now they're just inviting discussion
Yeah.
about why would you emphasize one but not the other? I mean, and I'm
Yeah,
sure.
and again, you're sitting here thinking, how can you always put your foot in your mouth? But they do it every time they do something
Yeah.
to kind of squash all of, because it just, there's 2,500 people watching us sitting here, and what are they going to talk about on Twitter when we close down this show? When did they receive the emails? You will probably be on with the young jerks tonight, and someone will come back and say, could you talk more about those emails? What does it mean? And again, it's constantly that the DA's office are idiots, in my opinion.
Well, one of the fascinating things about that DA's office is their instincts appear to be so ass backwards. I mean, anytime they should look left, they look right. Anytime they should go forward, they go backwards. They just seem to have the worst instinct on how to deal with this, and also the public relations component of this as well. Whoever is doing their, PR and their public outreach, they need to reevaluate what they're doing, because it's terrible. They have the worst press shop in that office.
Palola's mom, will the next jury know about the federal investigation? All of Massachusetts know the Karen Reed case. No juror hasn't heard of this case. We talked about that a couple of weeks ago, about at some point the state will need to ask for a change of venue, because everyone knows this case now, and it's
they can't.
They can't, but they can't. It can't get anyone. They had standing rallies for her yesterday everywhere in the state.
This is what we were talking about yesterday on another stream. This is why everything about this case is so bizarro world. The defense doesn't want to change a venue, because putting aside, all these loud trolls who live in the attic and threaten lawsuits and, do all that stuff, the reality is the public perception here is probably 85, 15, 90, 10, that at a minimum, she's getting screwed by these people and is probably not guilty, and worse, framed, right? I mean, that seems to be the overwhelming public view. So if you're the defense, you're not looking to get out of there. Like, you have, believe it or not, a friendly forum. Now, you leave it to like the coffin daffers of the world, who a couple of weeks ago were saying, oh, the DA needs a change of venue. and this is what finally I think got me blocked from her. Finally, the response to say like, okay, let me explain to you how this works. You are Michael Morrissey. You are the elected DA of Norfolk County. Those are your people who have entrusted you, your voters, your constituents, to do justice in this county. And you're saying I need to move because these rubes can't give me, these morons can't give me a fair trial? Or might you say, maybe they know something I don't know. Maybe this is a bad case. But the one thing no DA is ever going to do is tell a judge in a court filing or on the record in court, I need to be relocated out of my county of rubes who voted for me because they're morons and not being fair. That is just...
I have to interject. I've seen Morrissey. I wouldn't put it past him saying, hey, these idiots voted for me. I need to find somewhere where there's intelligent people. So
I think you're gonna this is never going to leave Dedham. There's just no reason for it. I mean, the only reason the defense would even want to get out of there, and this is not a strong enough reason, is to welcome Lally and his people to the discomfort of trying a case on the road, which sucks.
Yeah.
It does. I mean, that I can speak from experience. That sucks. But that's not a reason to relocate the trial because, Lally has to drive 30 miles or stay in a Motel 6 instead of staying at home. They're in the right forum, and you're not going to get rid of the judge you don't like. She could go with the case. So don't even get that idea.
Yeah.
Yeah.
Melissa asked, do we know if when she declared the mistrial, she had the verdict form in her possession? It appeared to me that she didn't, but I could be wrong. They never filled it out, so it wouldn't have changed anything. Mark, can the defense use Turtle Boy steal Daniel's video to discredit Chris, Colin Albert, to show evidence of aggressive, violent conduct?
Well, disclaimer here. We're talking about the Karen Reed case and the Karen Reed case only, right? Right. Correct. Yes. Okay. No, I mean, first of all, if you're the defense, I don't think you'd want to do that. I mean, Jill Daniels.
You'll open the door for bringing more Turtle Boy. You
are absolutely opening the door to the evidence that they wanted to keep out, but also there's still this concept of relevance. In the grand scheme of the Karen Reed case, who is Jill Daniels? She's irrelevant. She's nothing. I don't even know if her name got mentioned. Now, Chris Albert and Colin Albert are very important witnesses, but if you start getting into these other things, why would the defense want to do that? So they wouldn't even want to do this. There's plenty of other stuff about Chris and Colin Albert related to the case than, that spectacle that occurred in Canton a few weeks ago.
And thank you so much, Truth and Transparency. Also a great channel people should check out. And thank you so much, Miss Shorty, for 10 gifted memberships. And then someone wants to see my forensic diagram of the SUV hitting John. I think they mean my very accurate depiction.
You copy that from the video of your friend with the Prius video, or?
No, I was talking to the crime scene and it told me how it happened. So
right. Look, you might be able to be like an assistant for microdots. Like your level's right up there with,
It's so close. It's
so close. Keep practicing. So close.
I'm still waiting for my answer on the Bush beer. Right? That's noticeably not.
What I'm doing with the post-its, like when Miss Shorty gave me 10 memberships, I'll put it on. It's color-coded like the super chats and stuff like that. So I remember how lucky I am people contribute. It's because I'm not a big enough grifter. I should just sit here and say, why do I pull up questions where I'm not getting paid? Come on.
If you're keeping color-coded records like that, you belong in the Grifter Hall of Fame. You got to. What more can you do than that?
Well, it's even more sad than that because I do also. Can I turn it all the way? If you look over there, I keep the receipts when I empty my boards. So. So yes, I'm a really bad grifter because in Denmark we have a we have what's called the Yande law, that no one can be better than anyone else. That's why we're socialists, because everyone is equal. So it's just some weird thing I have. I like it. How many jurors have come forward so far? 5.
It's unbelievable. That's
Today was just one of those who were double hearsay, is now hearsay.
That's assuming that the ones that emailed Lally are the same ones that reached out to the defense. But we don't, we have no way of knowing that because he didn't bother.
what you got today, which is interesting though, is, it was one of those jurors who was kind of the intermediary. So there was that extra layer of hearsay, and now, they've had direct contact. So that, that obviously is a much stronger piece of evidence than it would have been through, I know a guy who knows a guy. I hate to always use Breaking Bad analogies, but, I know a guy who knows a guy can help you out. So it's a much stronger connection now.
Yeah.
And it's also a signal to, I think the last 2 have been signals to the DA's office that we're going to go to the press with this because we don't like what you're doing.
Right.
Because she came forward, confirmed that the emails or the text message that Janetti had seen was correct. She could just have kept her mouth shut, but I think this is another way to pressure them.
Well, yeah. And, this is something else I'm sure we talked about in the past. I know I mentioned it somewhere. I think it was with you. If these jurors get ignored, they dedicated 2 months of their life to this case. And it's a really unfulfilling result. Now, the result is what it is, but very unfulfilling to basically, okay, thanks for your service. See you later. And then when you try to correct the record, you apparently get blown off by the DA. And if this goes nowhere, such as the DA says it should, you have to live with this on your conscience if Karen Reed gets retried for murder and God forbid gets convicted when you already acquitted her. Do you not think that those jurors are going to speak publicly and tell everyone, look, we acquitted her. I'm just letting you all know, and I'll tell anyone and everyone who wants to listen. I mean, that's just common sense that one or more of them were going to do that. Again, the DA's press instincts, their instincts about everything is 180 degrees ass backwards. I mean, how they didn't see this happening. And look what it got them. It got them that kind of really critical article, or the way it was perceived, where Christina Rex wrote the article that, jurors are saying the DA is not responding. And only then does the DA, in a reactionary filing, respond, because they have their instincts are wrong. It's always out of order. They should have done that before. They would look like they're disclosing. They would look transparent instead of reactive to bad press. But
yeah, and again, it gives us something to talk about, and which they shouldn't have. They shouldn't have us having. We should be talking about this Friday, and then we should talk about it again in November when they have the next hearing, and December when they have the next hearing, and then we go into January and the retrial starts. You still have 2,500 people watching us talk about another filing in a case that should be closed for the next couple of months.
Yeah.
What about how she wouldn't recuse herself? I think that's back to when you talked about Bev was bad because she was supposed to
video
rotate.
of that? Is that hearing on? I mean, I'd have to watch that. Again, in all fairness, I'm not that familiar with it. I've seen the pictures where the lawyers, blew up the text messages on a big board or whatever. Which I'm sure she loved, by the way. But I haven't actually seen, and I'm not that familiar with what the evidence of that was. I'd have to go back and see that before saying anything, because I'm just not familiar with it that well.
And Buzzing for Truth says, hits to head, too many to count. Not sure. That's the problem with us talking, and I'm pulling it up as we have a lull. Sometimes I don't know what we were talking about at the time.
It's not a great lull for them. I mean, look what's happened since the case was.
No, I meant a lull in the conversation is when I pull up chats. So that's why they are out of order sometimes. I'm thinking, what the F is the chat about?
Well, maybe it's an unrelated point, but I'll just make it anyway. When the case was ostensibly declared a hung jury, normally you'd think, all right, they'll set a new date. Things will happen. Every now and then there'll be news cycles. It'll go up and down as, because the case is. But for the most part, it's going to quiet down. And instead, in basically a month, right? Maybe a little more than a month is when the jury was hung. What you have had happen is nonstop coverage because she was acquitted probably of 2 counts. Proctor is basically 90% to the way of terminated. And his 2 supervisors, who are also key witnesses in the case, are under internal affairs investigation. Other than that, it's been going great for the DA since the trial ended.
Yeah,
And it's going to get worse.
I just sent you the link to that hearing so you can watch it when you
good.
want
Thanks. Thank you.
And Susan says, I'm a bit behind on the live, but when FBI concludes the investigation, will they come out with their conclusions publicly? It depends on what.
Yeah, they don't. Well, first of all, let's be clear. It's the U.S. attorney who's running the story here. The FBI does the meat and potatoes investigation, but the U.S. attorney is calling the shots. So if this ends up with nobody being charged in anything, then the U.S. attorney's office is not in the business of publicizing people who are investigated but not charged for things. They just don't do that. So it really depends on what happens. If it goes nowhere, then it would probably just die down, although they probably would take the step, which is a rare one, but they would probably give a very generic statement to say that, whatever this has to do with the investigation into the murder of John O'Keefe and related issues, there's nothing going on. But they wouldn't say Michael Proctor is clean or dirt, I wouldn't be surprised if they just tell the world enough speculation, it's over. But obviously, if somebody gets charged, then this is going to ratchet up to a whole nother level, because that's going to be huge.
And why would the Alberts cover for Higgins? Why would Higgins cover for the Alberts? We don't know.
I don't know. I mean,
so
look, they're kind of weird people. Look what was going on. I mean, they hang out in a bar and, I guess, according to Matthew McCabe, grab ass like it's normal. They like to fight. They like to pose with their booze and, what do they say? Their Canton salutes or making punches.
Their fists, yeah.
Doing this. They leave these ridiculous videos. Look, they're a different kind of people than maybe a lot of us are used to. Alcohol is obviously the common denominator in their social life. That seems clear. They can't even pass up the bar on the night of a blizzard. Most people probably would skip the bar that night. I don't know, whatever. I don't know. I mean, why would they cover up for each other? I don't know what they know or don't know. What I do know is it cover up or is it intimidated? I mean, one of the things that they asked Higgins about, if you remember, although the objection was sustained, but that doesn't mean we didn't all hear it. They were implying that Higgins was telling the FBI, even Berkowitz is intimidated and scared of Brian Albert. They wanted to ask Higgins about whether Brian Albert kicked the crap out of another Boston cop over something, the guy he went to New York for the funeral. So obviously the inference is that Higgins is a big guy, but who looked like a tougher guy, Higgins or Brian Albert? I think 100 out of 100 people would say Brian Albert, right?
Oh, he was like a nice grandfather in his woolen sweater, and he was such a calm, reassuring. And then we saw him in the bar doing all the rhino dance, and you just saw, yep, I met cops like him all over the world. He's a big POS.
I will tell you, though, that Brian Albert was a hell of a lot more polished witness than Higgins was. They weren't even in the same grab.
Yeah.
He projected visually as, like you said, a grandfatherly, calm guy. And, whether people agree or disagree with that, he was he didn't get ruffled. He didn't get razzled. He was calm. Even when it came to some testimony that was very ridiculous about, butt dialing with Higgins as he's in the act of lovemaking with his wife, which nobody believes. Obviously, 2 butt dials back and forth within a minute. That's probably statistically impossible.
I'm
getting
just
rid
saying,
of
I actually made my theory because apparently Coco wasn't making too much noise, so there's a reason why the phone was in bed with them on vibrate.
Oh
Because,
gosh, too much.
well,
Too
I'm
much.
just saying that maybe Bri got a little bit of the whiskey dingy dong.
It's a good time to
My
like.
idea
I don't
is
want to picture that.
No, nobody
getting
wants to do that.
Brian Green and Microdots together to do presentation of impossible hit with SUV. I don't know if they are allowed to produce stuff like that, but because I would really have that visual of how tall John is compared to the SUV. Because Paul was saying his arm was like that, and Nelly was saying his arm was like this, and just to show how ridiculous the idea were. And Lizzie B is saying Higgins in the waterfall video, John doing the alley jig. Je ne sais pas.
Hmm?
I don't know.
I think one of the other things you'll see the defense do, it just, now they're talking about the waterfall and the bars. And again, this comes down to Buchanan and Proctor and whether they're available or credible. My recollection of the testimony about, the drinks, they really glossed over that.
Yeah.
Some of that could have been water, not all of it. And I don't remember. I don't go back and rewatch video. I don't have the time, but I don't know that she got 9 drinks or this, or what was alcohol, what was water. And they just kind of made it clear that it was. And I would expect, given if there's a retrial on count 2 where alcohol is an important part of it, much more vigorous attack on that.
Especially because the receipts don't line up with the amount of alcohol that they're saying. So
Right.
seeing that, the way that they, I agree. I think that if you actually break it down to what was on the receipts and what we see her getting, we don't know what was what. And especially with her, having health issues, we talked about this before too. Like if she, is getting, if some of the drinks that she's getting are soda water or Sprite or something, and then she's, just the shots or what she's putting in there or whatever, we really don't know what was what and, what she was drinking, because what they said and what the receipts are 2 different things.
Right. And I think you would also need, if you're going to do this the way the DA wants to do it, you would need to have a complete video for the however many hours Karen Reed was there, where you don't lose sight of her and see, does she hand them off? Does she drink them? Is it, is she putting it down and picking up the same glass? I mean, you'd really have to dedicate the time. I mean, what would she have been there for? A couple hours at most? And they didn't do that. They just had snippets of, as the commenter is saying, of, Buchanan saying, I counted 9 drinks. Well, that's great. You also said that, taillight pieces revealed themselves. That doesn't mean it's true.
Yeah. Yeah.
Yeah, and that's one of those things. I think the second go around will be better, because I would have objected, stating that Bev had told Alan Jackson so many times he wasn't allowed to editorialize the videos.
That's a really good point, because what you're not supposed to do is editorialize, as you said, a video. The video speaks for itself. I mean, you can certainly say, do you see a person there wearing these clothes, and what was that person wearing? I mean, you can use common sense to kind of frame the video and make your point. But what you shouldn't be doing is having someone like Buchanan testifying what he says the video shows. I mean, that is not appropriate. You're right. The jury is facts, not Buchanan.
She had admonished the defense, but again, that's where I think people think that it's kind of two-tiered system in her courtroom, because she didn't hit as hard as on the state.
But that's true. That is true. I mean, I don't disagree with that. I think she was harsher on them and gave.
But we see that in other trials as well.
We do, but she definitely gave the DA more leeway. There's no question.
Yeah.
And Stephanie says, I thought John didn't have a watch health data from phone. That's a Brandi question because I'm not 100% sure about that.
His was not the watch. His was the Apple Health data on his actual phone. So it still picks up. Apple Health will still pick it up if your phone is like when you're walking and stuff like that. It'll still pick up all the steps on there.
But wait a minute. But I don't mean to interrupt you, but this is like, I don't know if you have just a phone that the Apple Health data without the watch picks up stairs. Does it?
I believe so.
I can't remember getting stair data until I had a watch. Now, if I'm wrong, again, I'll be quiet, and I don't know. I wasn't aware of that. I thought you needed a watch. They're telling me, well, there's no and yes, so we're getting all kinds of answers.
I just looked up. So iPhone automatically stores and analyzes valuable health data, including steps, flights of stairs, and other walking data. Built-in sensors on your iPhone capture the number of steps you take, the number of flights of stairs you climb, and your walking speed and more.
See?
That's why you have Brandi on.
That and the commenters, I got shut down in 10 seconds and wrong. So off we go. So then it doesn't matter. So he had no watch. That's why I kept saying watch, but I guess really it doesn't matter. If he had the phone, he had the phone. But that would also mean he would have to be holding the phone, right? I mean, it's not going to measure if it's just lying in a car. I mean, that's another thing. How do you know he's even holding the phone? Not everybody sits in the car holding the phone.
Yeah.
No, actually, with the big phones, you have to. I always chuck it in the center console or use it as a GPS. So yeah, it's
which they were doing. They were using his as the GPS, which means he wouldn't have been waving it around and everything. He would have been, if they're looking at it as the GPS, then it wouldn't have been. You know.
Yeah, I mean, if you're gonna, if anything, just hold it steady. You can't read it if you're doing this.
Right.
No.
Something else may be worth, 7 seconds of cross-examination at a retrial too.
And Albert Morta says, I believe if defense exposed more of the Sallyport video, there wouldn't be a hung jury, not just pointing out the timestamp and inversion.
Well, remember though, they got sandbagged with that video. It came in the middle of trial, and they had to react quickly. And let's be honest, give credit where credit is due. They pivoted real fast and real well and got Buchanan on cross-examination and blew that thing up right away. But what they didn't have was time to analyze it, prepare it, think about it. I mean, they did it by the seat of their pants. Now they're going to have 6 months. They're going to send out subpoenas. They're going to send out discovery demands and say, where did this come from? Why is it in this condition? Is there another version? I would think they're going to be much more informed about this in the future. If there's a trial in January.
That's what I said. They have seen everything Lally got. He won't get new evidence, but they will get better. So
definitely.
But it's also really concerning too that the Sallyport video that they had this entire time, that there was even all of the arguments over in the pretrial hearings about the missing footage. It was that really dark video, and then all of a sudden here we get to trial, and this video that's so dark and grainy you can't see anything, and it's missing time. All of a sudden that's not all we have. Now we have this really easy to see video that is still missing timestamps here and there, it's still not a consistently run video, but you can see it, and it's how is that one available now when it was never, and they didn't have it available before? That's crazy to me.
It is crazy. And then you can peel the onion back even farther and say, so you have everything you just said about all the Sallyport, then you say, and look what's missing from the library. All that's missing is that critical thing to go with the library. And then you go to the Ring camera. What's missing? Oh, how convenient. Again, the statistical odds of the Sallyport video being screwed up, the missing library, right? The other missing video from the Ring camera, and the taillight pieces just being found weeks later. Who the hell believes that that's all one big, serendipitous coincidence that is not suspicious?
What's the saying? At what point are the coincidence too many to just be coincidences?
Yeah.
Well, if it walks like a duck and it quacks like a duck, it's a duck. I mean,
hey, we don't mention ducks on this channel because it's a hate crime.
That's triggering, right? I know we could all get arrested, right? No, we could all be arrested for harassment.
And an hour ago when we talked about the duffel bag, it has something to do with FBI removing that from a house. I don't know anything about that.
I have no idea what that means.
It's what that's. I cover a lot of cases and I cover this when things happen, but I don't go into all of the other stuff. Sorry, it's the dog talk. It got to me. But I don't know what that is. If this dust ever settles, what is the likelihood that some politician picks up the ball to challenge the witness intimidation?
Witness.
A witness. And guess which one?
Why do you assume a politician will do that instead of lawyers?
Yeah.
Stay tuned.
That's a...
Let's move on from that one.
Okay.
To be continued.
When is the next court day? Friday at 2 p.m. Eastern Standard Time. We will have motion hearings about should they be allowed to talk to the jury. Apparently, the so-called taillight embedded in John's clothes the jury struggled with. It's not evidence, though, something Lally spit out doing his clothes. Yes. And
yeah, it's
but again, it's true on the internet now because everyone is saying, but it's the microscopic plastic, which their own experts said, nope, didn't find any.
They have a very disturbing track record of making statements that are very sensational, but either turn out to be not true or inaccurate or get fudged. I mean, you heard about the DNA on the car, the glass on the car. The glass on the car turned out to be nothing, right? I mean, literally nothing. The human hair that was linked to John O'Keefe, what did that turn out to be? Maybe a hair, who knows, that, magically stuck to the car through, 50 miles in each direction in a blizzard. Who knows? This kind of was a pattern throughout the case. And like you said, the glass embedded in the shirt, that sounds powerful. But then you also realize that these clothes were in the custody of Proctor without even being booked in evidence for a period of time. And given what he is, who believes anything? I mean, that evidence is completely compromised. The same way, there's no dog DNA. Well, that may be true, medically speaking, but what was the analysis? Well, Proctor mailed us samples. So there, do you believe
it? And it was 2 samples of the clothes. We don't know where those samples were taken. We don't know. And with it only being the 2, they didn't send the clothing itself for the lab to do their own samples at, different parts. The dog DNA testing, no dog DNA being there, was such a nothing burger because it was so ridiculous that you would expect to find that on just that. And there were also the things that make it harder to read the DNA, like the blood, it makes it harder, and dye in clothing makes it harder to read the DNA. So there was so much stuff that affected that one. It's not even...
Yeah, I mean, in order to do a scientific test, there are certain principles and premises that have to be accepted to make it valid. And if you start out with the DNA examiner, for example, saying, well, I didn't examine anything, I was mailed swabs from Michael Proctor, that's it, you're done. The premise is gone at that point. Now, she may say, I analyzed the swabs, it's not canine DNA, but what does that mean? You've completely lost the premise of knowing the sample that you got, it being reliable, because it's coming from this dirtbag who may or may not, it's still, it was pig DNA. Could that be from a dog chew? It might be. It may very well be he went and swabbed, the pigsty. I don't know. You don't know what he did. He may have swabbed his own genes. Who knows?
Yeah. And that's again, but it sounds good because, it was an expert and they said DNA. So it's one of those magic tricks that you can use on jurors, because DNA, I've seen a CSI.
Yeah,
but didn't you hear that part where they also in CSI says it's 7 trillion times more likely to be this or that, or I can't exclude this and that. It was such a weak DNA statement for most of the evidence, and I swapped everything with 2 swabs, just all over the shirt, everywhere. So you contaminated every sample. That's impressive. And Senkat says, a law tuber I watched told her audience at the end of the trial that she thought Karen Reed was guilty because of the alleged taillight embedded in the clothing. I was stunned. I would be too. Because no such evidence. Apple built-in barometric altimeter sensor detects change in air pressure when climbing or descending a flight of stairs or hill. Yeah, but isn't it combined with the movement because of steps?
Yeah,
I thought you had.
you need, I mean, again, I'm not an expert on the science, but it has to relate to your body movement in some way so that it can tell that it's a human being doing steps and not, I mean, like, for example, if you left your phone on in an airplane until you lose service, you're not going to get 20 million flights of steps because the plane is going up if you're just sitting
Right.
there in a chair. So I don't, there's more to it than that.
I think you have to have that pendulum motion as well.
It's like
And
some form of kinetics, isn't it? Like the body has to be moving. I don't know.
yeah, I think it's 2 axles at. I don't know. I'm just making stuff up now to sound smart. It's
There's sensors in there. I remember reading about that. There's sensors in there that can detect when you're like the patterns of motion, so that when you're in a pattern of motion, then it can pick up that you're walking. So if like you just move your phone like this while you're holding it, it won't pick it up. But once there's a pattern that's the sensors detect, then it will detect walking, which is why the timestamps on there don't necessarily mean I started walking at this time. It means that the pattern started at this time, potentially, but it could have been any time throughout this time or whatever. If that makes sense.
It makes a hell of a lot more sense than the way I could say it. So that, yeah.
Yeah, we just smile and nod, boys. Smile and nod. Yeah. And Ellen says, Yandelow forever. Good and bad. Love Brandi and Bederow and Baker. You're okay as well. I'm from Jutland. It's another Dane. Thank you so much, Ellen. I think she's from the same town my brother lives in. Lizzie B is saying, Mark, if Higgins or Brian Albert or Chris were being prosecuted hypothetically, do you think a conviction would be possible or likely hypothetically? And I think this is connected to it. So it's Colin, not Chris.
I mean, you'd have to know, what are they being prosecuted for? What is the evidence? I mean, it's a little too broad to even know. I mean, I don't know what did Colin, I don't know what Colin did or didn't do. I know that some of his testimony was ridiculous. I know that when he said I hurt my knuckles from falling on the ice and landing on my knuckles, I know that's bullshit. I mean, that's
Right.
really not true. I know when he said I've never been in a fight in my life, that would appear to be, strongly untrue. I know when he said that I make it a habit to go up and kiss my parents goodnight and did you have a wonderful day every day, that's probably hard to believe. I don't know if it's true or untrue. I know that the timeline that him and his parents gave about him being in the house and coming home didn't match up perfectly, but did he do anything illegal in the case? I don't know.
Underage drinking, at least, but
Well, he definitely did that, but I mean, in terms of violence, I don't know.
no, it's. But again, it depends on what the charges are. Then hypothetically, everyone can be charged and convicted of anything. It depends on the
strength of the evidence, how credible it is, right?
And Jason says, thank you, Baker, for your videos. Hi, Mr. Bederow from Central Massachusetts. Thank you for keeping it unbiased with explaining the law legal processes for us. Well, thank you so much, Jason. I'm very behind, but I think count 2 was because Bev's wording. If you find Karen Reed set in motion a course of events that led to the death of John O'Keefe. Yeah.
I mean, if that's what happened here, then that's easily fixed. And obviously, when causation is an important thing in a crime. You have to cause, your conduct has to cause the act that led to the crime. But that doesn't mean if you just, because I drove him to the scene and then he later got killed, that I'm somehow criminally responsible because I drove him there. I mean, I have a hard time believing that's what the jury did. I think some of them believe, whether they should or shouldn't have, that she hit him and was drunk. And, to me, that's the takeaway I get from it. I don't know why they would have concluded that based upon the credible evidence, but that appears to be what some of them did. But again, they're 3 short and it's never going to get better. So
Yeah. Yeah, this was the best shot they had from the state. And everyone start to calm down because it's 10:45 my time. So we will be ending. I'm just going to go through the last super chats and then I'm going to say good night to my wonderful guests. Kimmy, I checked the weather days after John passed. It was in the 50s rain. Why did it take weeks to find Taillight? There was no snow. Kimmy, I can explain this one because it was the Canton Triangle. When you go inside of the Canton Triangle, it's kind of like the Bermuda Triangle. There's a black hole situated right around City Hall in Canton. And it screws with time, distance, physics, weather. Apparently, Massachusetts, I found this out, had never had snow before either. It's I was amazed because I thought it's kind of the same height as Denmark. We do get snow. I know what snow on the road, but none of these people in Canton ever had heard about snow before. So just remember, inside the triangle, everything makes no sense. The less you think about it, the more sense it makes. The plastic didn't show up for 2 weeks because the snow had
Because they
to
said
melt.
so.
yeah, this is one of those things. I also think at a retrial, they're going to drive a truck through this. They do the search at night, which is bizarre. But according to them, if you credit the case, they do find some taillight. Again, whether it's planted or not, the evidence is that we found pieces of taillight, which there's no reason to think, because again, Proctor knows, he knew what the taillight looked like, according to him, that's a small piece of a lot of missing taillight. Obviously, in Proctor world, the taillight's got to be there. All right. The state police know the taillight, the rest of the taillight should be there. So the first thing you do is you leave at night. Why aren't you out there, I don't know, at 10 o'clock the next morning doing a search in the day? That just seems to be like a logical thing to do. They don't do that. Then when they show up and the first piece of taillight reveals itself, they still know we're a million pieces of taillight, or 45 as it were, short of the full set. Well, now it's melting. When they discover that first piece, why wouldn't you right then and there say, get your shovels out, let's go, we're going to get it today? They don't. It's like Groundhog Day. They go back the next day, they find another piece of taillight. Why didn't that day? Get your shovels out, let's go. Their ridiculous story is that it's like, it's the hand of God raising the taillight through the snow for everyone to see for 2 straight weeks. How anybody could possibly believe that, especially coming from these witnesses, is insane to me.
And then even telling them, oh, well, I just told them, when you're on the way to work, just drive that way. So that way, if you see any taillight, you can get that. Blew my mind. To just
want to see these guys cross-examine if these troopers or sergeant, whatever he is, testify at a retrial. They need to go after them hard on this and say, why wouldn't you right then and there dig it all up? Just drive by on your way to work and you found a piece of taillight and you're good.
Yeah.
But you forgot, they did dig up the entire front yard, because that's what the search team did. They went through an entire front lawn, or removed the snow from the driveway to was it the fire hydrant he testified to?
Well, they missed the piece right behind the hydrant. There was that piece that was away from the rest of it.
Yeah, but that's what I would have asked them. Did you find this piece after the search team had dug the entire front lawn?
Yep.
Because how are they that bad at their job? So all the evidence they found, can we believe that, or should we believe you today? There's so many. When you hear it, it's just stupid. Thank God Mark Bederow have joined the fight.
Thank God.
Yeah. I believe that Sally Port is heavily doctored, and a movie editor, I bet, will show all the flaws the original splicer messed up on big and small. could be. I'm technically illiterate, so I can't.
Just,
You have to
just
talk to microbots.
appearing and reappearing. I mean, by definition, that's got to be altered, right? I mean, how does
Yeah.
somebody apparate in and apparate out of nowhere? I'm not a tech guy either, but yeah, we're back in the Twilight Zone, right? The Canton.
It's a triangle. Don't think about it. It makes it easier to get to and from work. You can just walk in a door and you come out and you're home. Oh, it's magic. It's like Doctor Who or something.
Yeah, don't question authority. Just accept what they say.
Yeah. Mark, how can we effectuate a change in court cases that will make only one closing for prosecution instead of giving them an upper hand advantage by having two closings?
I'm not sure I.
It's the response to the defense
Talking about like a
closing.
rebuttal? Well, I mean, I don't think they had that here, right? The defense went first and then the prosecution finished, which is how we do it in New
Yeah.
York. So, I mean, the party with the burden of proof, which is always the DA on these kinds of cases, they're going to get the last word. That's just because they have the burden of proof. But some jurisdictions, like federal court, the DA, well, not the DA, the U.S. attorney, they go first, then the defense goes, and then they get a rebuttal. I mean, that's an even bigger advantage. So,
Yeah, I don't think that's custom. You don't change that
Yeah.
so easily.
yeah, that's
Sencat-
another case.
Yeah, thank you so much, Sencat, for the 5 gifted memberships. And Lefty says, Baker is less than 300 away from 12K. I know there's 300 in this chat that aren't subscribed. Get him there. Oh, Lefty is grifting on my behalf.
I
Thank you so
subscribe
much,
because
Lefty.
we're grifting together, so I subscribe.
Yeah. It's the grift team.
I think I wonder. Sorry, this is off topic. I'm just thinking about the taillight. I wonder if they are talking about the planting taillight stuff. I think that one of the things that that I picked up on in the testimony that wasn't talked about a lot, which kind of surprised me. Tully, which is one of the ones who's under investigation now too. Tully said that before he went to Fairview, where the CERT team was, that he went first to Canton Police Department. So he would have been at Canton Police Department about the time that they were arriving with her car. And then he went straight from there to Fairview. And right after he got there is when they found the first piece. And if you'll remember, the piece was laid on top of the snow
Right.
for the picture to be taken. And they said that they laid it right there so that you could see where it was, but it had been dug out. I think that if I were going to argue the plausibility of planting taillight pieces, I think that I would have focused on some of that a little bit more, because I think that having the opportunity to do that was one of the biggest questions that a lot of people had. And the fact that he said that he went to Canton Police Department first and then went to Fairview, and that was right around that same time that all of that is happening, I think it could close some of that gap too for some people. And I'm not saying that he did it. I'm just saying that the possibility is that that closes that gap on the possibility that it could have been done.
Yeah, but that's important because obviously if there's no opportunity to do it, it didn't happen. I mean, it's a common
Right.
sense logic argument. There has to be a window of time. And that relates to like Proctor lying about the time they took possession of the car, backdating it an hour, or front dating it an hour. They really had that extra time. And from the defense standpoint, they're working with reasonable doubt. And if you can establish that they have an opportunity to do it, you sprinkle in on cross-examination that these people are under investigation for misconduct or terminated or whatever, it just gets stronger and stronger. Yeah, no, I think that's fair.
Yeah, and again, every time people who sits down like Brandi and just slots in all the data on a timeline, all the defense case gets better and better and better.
Mm-hmm.
And if again, Lally can't change it. He changed his testimony 3 times from opening to closing.
Yeah.
From when it happened.
Yeah.
And he changed the way it happened twice.
Yep.
In an 8-week trial, his case was so bad, he didn't even believe his own expert.
Yeah. He contradicted his own expert and the lead detective and the Trooper Guarino, the head dude that was doing his the data stuff. So he went directly against all of the main people in his stuff. And if the main people in the investigation and the prosecution don't agree on how things happened, how can you expect a jury to? It, like, they're throwing out these different scenarios and different times on things and different, this is how it happened. Oh, but then this person says this is how it happened. If the main players involved, that would be like Yannetti and Jackson getting up there and saying two different things happened and then just hoping that the jury buys one. That is mind-blowing to me.
Yeah, that would kind of be like Yannetti standing up saying, well, I think he ran into the car and she didn't see it when she came out and drove away. And Jackson is saying, no, he got beaten up by a pack of wild wolves. It wouldn't make sense, but nothing made sense. But everyone, the last 3 super chats, and then we will be out of here. RBG, I thought she died. Thank you for your great analysis of latest events. Thank you so much for watching us. And Zachary, I just realized Mark is a male version of Rubia. That's another attorney. And now feel compelled to mock him mercilessly. Maybe you should go ahead and time me out now.
I have no idea what we're talking about.
Well,
do I want to be a
Rubia
male
is
version of Rubia, or do I not want to be a male version of Rubia? Probably not.
Rubia was on here. She's been on with my buddy, the expert, as well. She is a sweet, sweet lady.
Okay.
She is, I believe she's an attorney in Texas.
Ah, okay.
So,
all right, could be worse.
So,
okay.
Yeah, that's and to round it all off, Brandi, you covered this case with such thorough research and integrity. I'm sorry you've been getting grief from trolls. You have my full support. Baker, go buy yourself a Mikkeller.
Thank you.
I'm Danish. I drink Danish beer because we have great beer. And of course, Andy just wanted to come in and says, does the carport video look like a Zoom background?
Wouldn't be the weirdest thing that happened in this trial.
No.
I think you have to ask Microdots about that because he's a tech wizard. I don't
only when he tells us about the Bush beer first. Priorities.
So funny.
Stupid mosquitoes. Everyone, thank you all so much. Mark, would you be joining someone tonight, or do you have a night off now? I don't first.
I don't think so.
Well, maybe Mr. The Young Jerks will be reaching out to you before long.
Okay.
There's a video of Higgins calling over to John at bar when leaving. John, last one at bar, looking at Higgins while doing a boxer's movement. Higgins signaling John over to the exit. Yeah.
It's weird.
Watching that video put Higgins on my top list of accidents that made John pass away.
And you have to look at that with, again, are you coming here with all the,
all the question marks?
I mean, he was fired up for something.
Yeah.
And remember, he was texting Karen at the bar. Are you going to say hello or something? He was still kind of enamored with her and she was ghosting him. I mean, this is all happening at the same time.
Yeah. And that's why, because when I went in there, I didn't know much about Higgins other than that weird he went to work at 1:30. But especially the ghosting Karen did to him, she wanted a little action and figured out he was a big nothing and started ghosting him, because when you saw the text, he was constantly, hey, how you doing? How you doing? How you doing? It was kind of like me with all my ex-girlfriends when I'm drunk. It never works.
I think she wanted like emotional support in a moment where she was struggling with things with John. I think that they were arguing, and because she had so much frustration with how he was not happy with anything that she did with the kids, I think that talking to another person who doesn't have kids, so there would be no kind of expectations to where she's not constantly feeling like a failure or being told she's a failure. I think that was probably appealing to her, like, to get not only emotional, attention, honestly, because she wasn't getting it, but then also getting it from somebody who there's not a chance of her going through those same issues. But it's not what she really wanted. I think it was a temporary, fix while she was in a low point. And then as soon as she realized that, she was like, I'm not dealing with this anymore. And she moved on, but I don't think that he necessarily did.
No,
That's just my theory.
And again, you could clearly see the text messages. He wanted more.
Yeah.
Because she admitted she kissed him. He said, yeah, it was just a peck on the cheek. Yeah, it was a boring. Yeah, you wanted more. It was him really wanting more. So, Brandi, what are you doing now? Are you still on vacation?
Kind of. Well, I've been working on the podcast. I've got a lot of stuff going on with the podcast right now, so I've been working on that. I'll be doing the hearing on Friday, but I don't think I have anything else scheduled until then. Just working on the podcast. So I've got this week's episode though. I'm so excited about the engineer that I talked to that has his reconstruction engineering firm. I sent him all the information, and I had a conversation with him about Trooper Paul and the text stream data. He's been working with text stream data for like 20 years. So I talked to him about it, and I'm going to put that in the next episode. I'm so excited about it. It's very interesting.
It's for those of you all know Brandi. She has some of the most highly worked through and most detailed podcasting out there. We are just peons next to her. We're talking heads. She's the smart cookie. But the rest of you are also really smart cookies or muffins, whatever I call you today. Mark, thank you so much. Brandi, thank you so much. And I'll try and see if the Sarah Boone video at some point leaks, or maybe I'll be starting a new trial from Nevada tomorrow, just to keep us going till we get to Friday.
I think Sarah got delayed because of the hurricane this morning. Is that what?
No. Marissa called court. They were just delayed. She have been in court. They have ruled on or discussed several of her motions, but they postponed it to.
It just got delayed for later in the day. Is what you're saying?
They're actually going to go Friday too.
Gotcha.
So they were at court because I got all those rumors as well, but court was on. But
stuff was blowing up this morning.
Yeah, but motions were heard, but I haven't seen the rulings yet. But if the video comes out, we will cover that, or else I'll probably look at a case from Nevada tomorrow. Other than that, nothing else to say than hasta la taco, and where's my outro?
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100% correct.
So you literally built a cannon?
Yeah, it's pretty awesome.
All
right, I'm in love. Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there-
Everybody has.